most responsible for the crimes. These are the jurisdictional conditions the Supreme Court chamber shall reconsider. As a matter of fact, the jurisdiction comprises of, first, personal jurisdiction, territorial jurisdiction, 3, temporal jurisdiction, and 4, material or subject matter jurisdiction. If the chamber has to finish admission by ending the culture of impunity, it shall consider carefully the crimes committed and also the personal characteristic of the accused. The scope of the jurisdiction has to be well determined by the criminal court because this is very important. Otherwise, it would infringe the rule of law and or the legality and the chamber itself. Regarding the temporal jurisdiction and the territorial jurisdiction and subject matter jurisdiction, and at the same time determining the crimes committed are very important before a trial court or a court of law. This matter of personal jurisdiction may not include individuals or some key people who do not fall within the jurisdiction of the court. The material or subject matter jurisdiction will guide the court in relation to the crimes or the offences committed by the accused person, and that the chamber shall make a decision to identify whether such crimes are international or domestic crimes or just very simple or ordinary crimes domestically. In order to achieve this purpose and to eliminate impunity, the interpretation of jurisdiction has to be rather broad and well considered, and it shall cover both geographical features of the locations, the offences itself and themselves, and the people concerned. However, according to our study, other tribunals have not maintained their position according to its wisdom and conscience. Other hybrid tribunals have compromised a lot during the course of admission when it comes to these matters. According to Rule 11 bis and the jurisprudence of ICTY, the term senior leaders have been very well defined. They refer to those people whose roles and responsibilities were in the administrative hierarchy according to the law, de facto, and de jure. And they were within the positions that could be considered as the most senior people, not the middle-level people. Dutch himself hold a very lowest rank during his time. According to the same jurisprudence of the ICTY, the identification of the roles, for example, the people who hold position in the standing committee or senior positions and political positions. For example, According to the negotiation with the international components, and only after such negotiation that people's positions could have been verified. For example, if the accused have negotiated with international counterparts, that the chamber may find him responsible or be in the position of the very senior ones. According to the decision, Resolution 1531, the Security Council identified the criteria when it defined the senior positions. So who would be in these senior positions? Any order issued against a person must be issued against someone who was the senior leader of the regime. According to the personal jurisdiction by the Sierra Leone courts, it sets this clearly that individuals who have committed crimes, grave breaches against the humanitarian law, and that the Sierra Leone law also includes or covers individuals who have committed crimes which have threatened the construction and the implementation, peace implementation within Sierra Leone. The personal jurisdiction of the ECCC has been referred to or has been stemming from the other important sources, the very controversial sources where the international bodies and Cambodian government had strong arguments. And at the beginning, when Cambodian government appealed the United Nations to help establish the court to prosecute only the senior leaders of the Khmer Rouge. And at the same time, the United Nations consequently agreed with such determination by the Cambodian government so that such agreement could be reached. Ultimately, this chamber has been established. The personal jurisdiction of the ECCC has its limitation to strictly prosecute only senior leaders of the Democratic Cambodia regime and those who were most responsible for the crimes within its temporal jurisdiction. ស្នើសុំឲ្យមានយុត្តាធិការបុគ្គលទូលាយជាងមុន Even there has been request for a broader interpretation of the jurisdiction so that the co-prosecutors could really have a bigger margin to maneuver when they would like to interpret this jurisdiction. However, such a request was bluntly rejected by the Cambodian government. Article 6.3 of the ECCC restricts the scope of investigation of the co-investigating judges and the co-prosecutors to only investigate crimes against senior leaders of the Khmer Rouge regime and those who were most responsible for the crimes under the ECC law. Therefore, the law binds the OCP's or co-prosecutors' discretion and the discretion of the co-investigating judges. These two bodies have to really stick to what's set in the rule, otherwise they would stray away from the law as set forth by the ECC law. During the trial proceedings before the trial chamber, the defense counsel for the accused challenged the court in relation to the personal jurisdiction over Kangek Eo alias Doj. The defense argued that the court had no jurisdiction over the accused and that there were ample evidence to prove that Doj has not been bound by Articles 1 and 2 of the ECC law. However, the judges failed to consider such argument and that the proceedings continued until its completion. Finally, the defense counsel tried again to include in our closing statement to request the judges to re-examine the exculpatory evidence proving that the accused should not be bound by Articles 1 of the agreement between the Royal Government of Cambodia and United Nations and Articles 1 and 2 of the ECC law. As the result, time again, the judges failed to review the exculpatory evidence as requested by the defense counsel. On the 26th of July 2010, the trial chamber issued its judgment in case file 001, sentencing Doj, the chairman of S21, which was under direct control of the General Staff and the National Defense head Son Sen. Doj was sentenced to 35 years of imprisonment. The trial chamber's judgment of the 26th of July 2011 convicts Doj, and that although he has not been falling within its jurisdiction, the defense would like to maintain our position that the chamber shall review its consideration in relation to the definition of the senior leaders and those who were most responsible for the crimes before this court. At the trial court, the defense counsel only challenged the methods employed by the co-prosecutors and the co-investigating judges and the trial chamber in defining personal jurisdiction over Doj. They try to include Doj in their jurisdiction ambit. However, the defense counsel is still convinced that Doj does not fall within such jurisdiction as follows. 1. Error on the personal jurisdiction by the trial chamber. Personal jurisdiction has been set against the senior leaders of the Khmer Rouge and those who were most responsible for the crimes and the grave breaches of violence against national and international laws. The agreement between the United Nations and the Royal Government of Cambodia regarding the prosecution under Cambodian law, the crimes committed during the period of the Democratic Cambodia and the ECCC law do not really set clearly the senior leaders and those who were most responsible for the crimes. In the agreement itself and in the ECCC law, no such provision are found that Kang Kek Yew was the most person responsible for the crimes committed. The question is, who were the senior leaders of the Democratic Cambodia and who were those who were most responsible for the crimes? According to other tribunals, the senior leaders could be defined as those who have been suspected of being responsible for the senior positions. It means that those people must have been the senior leaders. Only when those people were holding senior positions that they could really have the power to render orders or command, and that they were vested with such power, which was part of the criteria to define them as senior leaders. Otherwise, they would not have been suspected of being the most senior people or people most responsible for the crimes. Dodge was the chairman of a prison guard of a security center. How could he be considered as one of the person who's most responsible for the crimes? I would like to draw your honor's attention and the court attention to the categories of those who were most responsible for the crimes and senior leaders. I would like to start from those, the senior leaders first. Person who had the decision or vested with power to issue orders or commands. We may refer you to article, paragraph rather, 256 of the judgment. Anyone who ordered Dodge to commit crimes shall be prosecuted. Dodge who implemented the orders shall not be prosecuted because he received order from the standing committee or party center, and he was of course a perpetrator, but he shall not fall under the jurisdiction of the ECCC because he received orders from his superiors like the other chief of prisons. We therefore would like to request that the Supreme Court chamber consider this. The trial chamber conclude that Dodge was the senior or the most person responsible for the crimes. They did so only to make sure that the proceedings were positive. However, by doing so, they have infringed the rule of law. And also the Paris Peace Accord of 1991, which states that the Constitution prohibits any crimes committed in the past. This Appendix 5 really grants the amnesty to all the Khmer Rouge former soldiers and leaders or cadres. Article 21 of the agreement, the Paris Peace Accord, states very firmly that all prisoners of war shall be released, and civilians who were detained had to also be released. And when UNTAC came to Cambodia, these people were finally released, and some of them were seen sitting at the table, the negotiation table, and the Khmer Rouge was part of the party who also involved in the election. This suggests that these people were already pardoned. Otherwise, they could not be allowed to take part in the election. But I would like to stress that the Khmer Rouge at that time boycotted the election. So I can conclude that the law itself has already found them not liable for any crimes from 1991 until today. Article 7 of the Penal Code of 2007 states about the determination of criminal action, and that since the law already been in favor of the senior leaders of the Khmer Rouge, it means that they have already been free and from being prosecuted. The judgment of the trial chamber in case 001 is a sign of infringement against Paris Peace Accord of 1991. And at the same time, it infringes Article 7 of the Criminal Procedural Code of 2007. Allow me to make it clear that 20 countries signed on the agreement or the accord on the 23rd of October 1991. It means that these 20 countries have to abide by this law. And when the Thai invades, there was a dispute between Thailand and Cambodia at the border. There has been an appeal to the international community to really force Thailand to respect this law. And now it is the same at this tribunal, that the ECCC shall also respect this rule, because when Thai does not really obey this regulation, we say that Thai was illegal, and we believe that this tribunal would not really follow the footsteps of Thailand. So I can conclude that when Deutsch being implicated as the person falling under personal jurisdiction of the court, it is really not acceptable, and that the Supreme Court chamber is now vested with the power to review these jurisdictional matters, in particular to define the persons who most responsible for the crimes and senior leaders under this ECCC law. During Dutch time, during the Khmer Rouge, there was no law. It was a line. The party line was used instead of the law. There was no court of law. And if there was no law, there was no crime. So Dutch did not really violate Geneva Convention of 1949. Dutch must fall outside the jurisdiction of the ECCC. The Defense Council is optimistic that the Supreme Court chamber will consider the law as in the case of FENTA in Canada Court of Law, when the Supreme Court chamber of Canada found that FENTA fell outside the jurisdiction of the court and that he was released immediately. Appendix 5 of the agreement states further that an individual who violates or who has been violated can appeal such a decision. Now, Dutch has already appealed before the Supreme Court chamber, asking this chamber to respect his right as envisaged in Appendix 5 of the Paris Peace Accord of 1991. According to Article 5 of the law on the outlawing of the Democratic Cambodia Group, states that this law allows 6 months after its being enforced the Khmer Rouge leaders or military groups of the Democratic Cambodia to return or to integrate, to live under the administration or rule of the royal government of Cambodia, and that they would not be punished for any crimes they have committed. This standard shall be also considered. However, the trial chamber failed to do so, and this really harm the Cambodian law enforcement, and it's really against Rule 87.1 of the internal rules of the ECC.
Therefore, for the spirits of Article 5 on the outlaw of the Democratic Group, it clearly states that there will be no punishment for offenses they committed. For that reason, even if Dutch committed any crime, the law would not punish him. Dutch therefore shall fall outside the jurisdiction of the ECCC in pursuant to Article 7 of the Code of Criminal Procedure, that is the extinction of the criminal action. Because of the general pardon stipulated in that law, according to Article 6 of the same law, for leaders of the Democratic Cambodia Group, they cannot be pardoned. So, in the spirit of this law, all the perpetrators, co-perpetrators, accomplices, they shall not be punished for crimes they committed. Only the leaders of the Democratic Cambodia Group shall be prosecuted, and though he is merely the chief of a prison, and similar to those chiefs of the 195 prisons throughout Cambodia, that they were considered by the trial chamber as perpetrators and they failed outside the jurisdiction of the ECCC, and why only Dutch out of those 195 prison chiefs failed within the jurisdiction? And I would like your honor to pay attention to this point. Article 9 of the law of the outlawing of the Khmer Rouge clearly states to that effect, any person who violates the law and violates the right of the people by wrongly accused or wrongly making arrest or detention of people